if these comments may be highlighted, the remarks of the Honorable Portfolio Judge, it is very important. At para number 4 on page 88 only. If I may read these remarks.
You will read. Remark 4. Remarks.
Yes, sir. As per general assessment note of Sri Kaustubh Khera given by Principal District and Sessions Judge Bench, Sri Khera does not take any interest in judicial work, but more on extraneous subjects. I personally met him, who told him from the last 6 months he is having matrimonial problem due to which he is mentally disturbed. From his side and his wife's side, the pending matrimonial matters are disposed of. He came there in April 2022. Previously, he was the target in regard of disposal of cases. He was posted at Betulman, where due to COVID pandemic situation, there was a lockdown. Besides this, for 15 days, he was at Jyotri, due to which he could not achieve the target in regard to disposal of cases. I talked with Sri Asim Ahmed Abbasi, Additional Judge Leher, who has inspected the work of Mr. Khera, and from that, Mr. Khera requires some guidance and when required, as he is new at present place of posting. Besides, there is no shortcomings in his work. He commands good reputation. It is true that Sri Khera could not achieve the target of disposal of cases, but looking to his personal problems, ratings be given to him by the Principal District and Sessions Judge Board requires to be upgraded, therefore is upgraded to C in place of.
Right. And I made a representation in this slide only, your lordships.
Right. Right.
Then, Marot, next page is the final approval by the Honorable Chief Justice as C. Marot. Then, Marot, may turn over to the next page. This is for the year 2023 documents. Marot may come to part 2 again of this. That would be on page 97. Now, Marot may say it's a table, Marot. It's in a tabular form. Marot may have a perusal of this. Quality of judgment order. This is on page 97. Marot.
Yes, sir. Yes.
1A, language satisfactory, narration satisfactory, clarity in thought, good, conclusion, good, knowledge of law, good. Then next page. These are nothing adverse heard, but these are all good and very good. Between good and very good, satisfactory. One is satisfactory, meaning that item number is.
Right.
Then Madam may come to the next page. Overall view. Though he has disposed of 96 out of 100 listed cases under this debt scheme and has also earned average of 8.04 units per day, which falls in very good category, the quality of judgments ordered, orders passed by him is below expectation. The judgments orders are written in very slipshod manner, lacking discussion of evidence and margin. Copy of inspection note for the goes with that. Rating was given C by the London District Judge, inspection judge, District Judge inspection. Then Marot may have a perusal on page 100. Marot. This is the by the Honorable Portfolio Judge Marot. And the final rating which has been awarded is D. Marot.
And I have been upgraded on all these parameters.
This is also part of the reason you don't have patience. At judicial office should have patience. 3-4 times we warned you. Let him complete. Don't interject like this. If you wish to, you just note down. This is what the problem with you. Yes, please.
Paragraph 5, Marot. The comments recorded by the Honorable Portfolio Judge of the District. I agree with the assessment made by the District Judge, inspection boiler room. Then Marot may come to the next page. Overall view, serial number 11, Marot. Rest is all agree, Marot. Very good. Overall view is very good. And then grading has been given, very good. Final grading awarded by the Honorable Chief Justice. So on the basis of this report, Marot, the comprehensive assessment chart was prepared, Marot, and that was placed before the Honorable Administrative Committee, Marot. That we have placed on record. That is that minutes is there, Marot, on record. That is page 33 of my return, annexation R26. Marot, see, discussed last paragraph on page 33. Discussed and resolved that Sri Kaustubh Khera did not utilize his probation period successfully and satisfactorily. Therefore, having considered the overall circumstances, the committee resolves to recommend that the service of Sri Kaustubh Khera is no more required to be continued and refuses to grant him confirmation. Accordingly, it is resolved to recommend that Shri Kaustubh Khera be discharged from service as per Rule 11C of the Madhya Pradesh Service.
Yes.
Thereafter, my lord, the matter was placed before the Honorable Full Court, R2, Annexure R2 7, Rakshipad, page 36, where it was approved, my lord. Now, submission is this, my lord, in the entire assessment of the record, my lord, there is no adverse statement has been made against it with regard to any of his conduct or any other part. The entire writ petition has been filed, my lord, on the basis that he is being penalized. And it is in fact a penal discharge. It is not a normal discharge. However, the submissions are not borne out from the record. I am relying on only one judgment, my lord, which I have put in reference in reference to the cost of the. I'm relying, my lord, in fact, I put it on the reference, it should disappear. So I'll just give the citation, my lord.
Yes.
2023,
Yes.
volume 9.
First one.
Yes, sir. It's available with your document.
Punjab versus Jaswant Singh.
Yes. I am relying from paragraph 16 to 24, my lord. In this case, my lord, you are the police officer, my lord. And as per the rules, my lord, you were told that he will not be a very good police officer in future. On that basis, he was discharged.
Right.
The Honorable Supreme Court has said that it is not a criminal discharge. It is a discharge during probation for improper. The appreciation of his services was that he would turn out to be a good officer. So it's not a big deal. That is.
Yes. Anything also?
Your Lordships, as far as the service record is concerned, my service record for 2024 was also considered by the committee as per the record. It is on page number 32, Your Lordships. If I may draw Your Lordship's attention to that.
Yes.
Your Lordships, civil unit required in an year is 330. By June, I had 446. Average per day, I was performing 14 units per day. 7 per day is very good for a judicial officer, Your Lordships. I was performing at 14 units per day. I was doing work equivalent to 2 very good officers as per the unit criteria. This is the year of my discharge. And moreover, Your Lordships, in 2019, that is my first ACR. It is very good. No adverse remark. 2020, it is good. C, no adverse remark. As far as 2021 ACR is concerned, Your Lordships, I had made a representation and it is on the reply of the respondent that it has been rejected. They have not placed what representation I made and on what ground it was rejected, Your Lordships. I made that representation in light of the upgradation given to me by the Honorable Portfolio Judge only. So anyway, it is on record that the Honorable Portfolio Judge has upgraded me. Similarly, in 2022, Your Lordships, I had made representation in light of the upgradation given to me by Honorable Portfolio Judge. They have not considered the upgradation given to me by Honorable Portfolio Judge. They are relying on the adverse remarks given to me by the respected district judge. However, since the Honorable Portfolio Judge is the reviewing authority and it has been finally approved by the Honorable Chief Justice, so the adverse remarks could not be read against me in light of the upgradation given to me by the Honorable Portfolio Judge. Similarly, Your Lordships, in the year 2023 ACR, if I may draw Your Lordship's attention to page number 100, wherever I was marked, first Your Lordship's attention, if I may draw to page number 97 of the paper book, wherever I have been marked as satisfactory, the Honorable Portfolio Judge has upgraded me on page number 100. He has upgraded me, His Lordships has upgraded me to good, wherever I was marked as average. So he also upgraded me overall from good to very good, from C to B. And Your Lordships, this adverse remark again that my quality of judgment is bad, overall view at 11. His Lordships has overruled it expressly by stating at the overall view at para number 11, page 101 as very good. So the Honorable Portfolio Judge has upgraded and this has attained finality, not the earlier adverse remarks. Your Lordships, even in 2023, this is the most important ACR because it is my first ACR after my probation confirmation was withheld and my last ACR before I was discharged from service, Your Lordships. If I may draw Your Lordship's attention to page number 95 of the paper book, I have earned 448 civil units, Your Lordships. Required is 330 for an year. I had earned 448. My overall units are 1641. Per day unit is 8. 7 is very good. I was having 8.04, Your Lordships. And this work got better only in 2024, Your Lordships, as is visible from page number 32 of the reply. By the end of June, I had 446 civil units. 14 units per day I am working, your lordships. So the assessment done by the respondent is not fair, your lordships, and in light of the judgment rendered by the Honorable Supreme Court this year only, in re-termination of civil judges, MP Judicial Service, that the entire service record of the officer has to be considered, and it has to be considered fairly, your lordship. So although I was a probationer, but my fundamental rights under Article 14 and 16 of the Indian Constitution were intact. Moreover, your lordships, if I may draw your lordship's attention to page number 188 of the paper book. Your lordships, as per the terms and condition of my service, this is the advertisement of mine, my recruitment advertisement. In it, it has been clearly mentioned at part 1, part A, section 3, clause B. It is at 188, your lordships. If I may draw your attention to that. It has been clearly mentioned that even during probation, I would be given 1 month notice before being discharged from service. This notice was not given to me, your lordships. The respondents have said that service rules prevail over the advertisement. However, this argument is flawed, your lordships, because harmonious interpretation is required here. Advertisement has been framed by the Honorable High Court. Rules have been framed by the Honorable High Court. It could not have been the intention of Honorable High Court that one would be given effect to and the other will not be. That is not the rule interpretation of statutes as per the interpretation principles of interpretation of statutes. Harmonious interpretation was required.
But if two things are there, rules will prevail or this will prevail? Tell us.
Harmonious. Rules 11C say I could be discharged anytime during probation, your lordships.
So therefore,
This says,
listen, the any institution has to go by the rules or act.
yes, your lordships.
Whatever written here and there, some
Your lordships.
notification suppose issued, that
Yes.
will not prevail over the rule.
It will not prevail, your lordships, but it could be interpreted harmoniously that I could be discharged during probation, but with 1 month notice. Because both have been framed by High Court only, your lordships.
Yes.
And this may not be statutory, your lordships, but this is contractual in nature, at least contractual. And if there is no conflict, both could be interpreted together. They have said in their reply,
Regarding 1 month notice, where it is mentioned?
is 3B, your lordships. If I may read for your lordships reference.
3B.
किसी भी पक्ष द्वारा 1 माह का सूचना पत्र देने पर सेवाएं समाप्त की जा सकती है. The respondents have said in their reply that advertisement only governs selection process. Service is governed by rules. So, your lordships, during selection process, the candidate is not on job. So, there is no requirement to remove him from service or giving notice to him. The intention of High Court is clear, your lordships, that this was applicable to the officer, and once the intention of the Honorable High Court is clear, it has to be given effect to irrespective of the consequences in light of the literal rule of interpretation, your lordships.
Right.
Moreover, your lordships, if I may draw your lordships' attention to page number 163 of the paper book. It's an exhibit P16, your lordships. At 11B, the rules, it has been stated that the maximum probation period could be 3 years. The respondents in their reply have submitted that it could be 4 years in light of the recent amendment. I was put on probation, your lordships, for 5.5 years. Despite good service record, my adverse remarks have been expressly overruled by the Honorable Portfolio Judges, 2 different Portfolio Judges, your lordships. There was not a case of favoritism. 2 Honorable Portfolio Judges, I have different Honorable Portfolio Judges have consecutively upgraded my ACR, and that has been ignored. Only the adverse remark by the reporting authority have been taken into consideration as per the learned respondent. So, your lordship, putting me on probation for 5.5 years. Despite good service record, I had very good in my last ACR. I am doing 2 times work of a very good judge in 2024. And more importantly, your lordships, at para number 31 of the writ petition, I had disposed of all 100 listed cases this year, your lordships, by June itself. All listed cases I had disposed of by August. Sorry, I was discharged in September. By August, I had disposed of all 100 cases, and they have not denied this. So it's a deemed admission on their part. They have not denied at para 31 of my writ petition. So listed cases I'm doing, civil cases I'm doing, overall I'm doing. ADR also in 2023, there is no adverse.
Regarding civil cases, what is your disposal?
Your lordships, it's on page number 32, your lordships,
Page 32.
of the reply of the learned respondent. 446 civil unit by June. By August, this figure was beyond 600. 330 required in a year. Within 8 months, I am doing 600 units, and admittedly, in 6 months, I am doing 446.
Just a minute. Civil units is January 43, February, this is total is 446.
By June,
Right. January to June. And what about the last years? This is
last year, your lordship,
20, this is 24.
23 ACR. If I may draw your lordship's attention to page number 100 of the paper book. 95 of the paper book, your lordships. Total unit earned in civil case 448. 330 required for a year.
Yes. What page?
95, your lordships.
23. 95, yes.
Yes. 448 civil units, your lordships. 330 required.
Civil cases 448. Right.
Despite it has been mentioned in the ACR that I was on EL for more than a month. Despite that, I met all the criteria, your lordships.
Mr. Adhikari, you are mentioning that civil side his disposal was very poor. That is not as per this record.
That has come in the report, Madam.
No, that is true, but record is there. Civil
Report is
side
there, but it has come in the because
report.
not only the number has also been given, Madam. The numbers have been given and the further disposal has been calculated on that basis.
No, that is true, but
Madam,
yearly units here under 448. Total year under and this is by district and session judge, signed by PDJ.
So the Madam, we see on page 89, Madam, 85 has been calculated in this year, Madam. Madam, we see the quantity of work. I'll just read this paragraph, Madam. Page 85. It's part of the ACR itself, part 2. Civil units 51.85, criminal units 927.69, other units.
No, this is of which year?
This is of the same year, Madam, to be my learned
22.
Oh, no, but,
22, same year.
but otherwise on that chart is more than 400.
That is 23. I improved.
That is 20. That is 20.
And 22, what is position?
22, your lordship.
Is same.
This less disposal I have been exonerated from it by the Honorable Portfolio Judge. I had a personal problem. I was suffering because of that. So Honorable Portfolio Judge at page number 88 has exonerated my less disposal.
And approved by the Chief Justice.
Yes, your lordships. And 23, I improved. I got to know that my performance is not very good. I have to safeguard my career. So in 2023, my confirmation was there. I was shocked that my career is not going in the right way. So my efforts could be reflected in 23 ACR. It improved by leaps and bounds. And 24, I was doing 14 units per day, your lordships. By June, I had 450 civil units. I made exemplary improvement. My earlier record is being emphasized, but the improvement I had made is not being emphasized. The whole purpose of extension probation was to give me a chance to improve. I improved. Yet my earlier record is being emphasized. Then what was the purpose behind extension of my probation? I had achieved the purpose of extension of probation. I have become a better officer.
During this period, any communication received from the High Court that you improve in this particular?
No, nothing, your lordships.
Not
I received these adverse remarks, but I had made representation to each and every adverse remark. And your lordships, they have admittedly rejected my first representation for 21. For 22, your lordships, they have uploaded it on Saturday after I filed my rejoinder. It says that it is in abeyance. Your lordships, copy. It says my 22 representation is under abeyance. It has not been decided yet. 23 also I represented in light of the remarks of the Honorable Portfolio Judge only. I did not rely on anything else. I just said if my Honorable Portfolio Judge is disagreeing with the respected district judge, then these remarks should not be read against me. And at least I could not have been discharged from service on the basis of these remarks, even if they were not expunged. It is under abeyance, so it could not be read against me.
We'll see. Heard reserved for judgment.
Highly obliged, your lordships.